Hello and welcome to a belated contract law introduction offer part 2. In this video we will pick up where we left off in offer part 1, which was starting to deal with invitation to treat and some aspects of that. An invitation to treat is distinct from an offer in all that it does is merely invite offers rather than indicate a willingness to be bound, which is what an offer does. It sets up a scenario that allows the party inviting the offers to be able to accept or reject an offer that is made to him. So a communication only reaching a level of an invitation to treat will not have any binding effect in the same way that an offer will. Some of the situations that amount to an invitation to treat include auctions, displaying of goods for sale, advertisements, tenders, and where, for example, someone is merely making a statement of price. The category of invitation to treat that we will start with is auctions. It is usual that an auctioneer will ask for bids. When he's doing that, he's not making an offer to sell to the highest bidder. For example, in Payne and Cave, which is a case that arose in 1789, the court said that the auctioneer was merely inviting offers from which bids he can then accept or reject the offer from that bidder. This law is now set out in statute in section 57(2) of the Sale of Goods Act 1979. This states that a sale by auction is complete when the auctioneer announces its completion by the fall of the hammer or in some other customary manner. And until the announcement is made, any bidder may retract his bid. That is the situation where there is an auction with a reserve. By that I mean with a reserve price, the minimum price at which the good will be sold. Even if people are bidding, if the reserve price is not met, then there will be no sale. But assuming that that reserve price is met or exceeded, then there will be a fully binding contract when the auctioneer's hammer falls. And for this, see McManus and Fortescue, 1907. So what of an auction whereby there is no reserve price? The question I guess to ask is there a binding promise when the auction has no reserve? Having no reserve means that there's no minimum price put on the item. So whatever the bid, no matter how low, will that be an offer, that low bid? The Court of Appeal deals with this, and that was in the case of Barry and Davis, 2001. There it was made clear that there is a binding promise when the auction is without reserve. So in this case, the material facts were that there were 2 machines advertised without reserve. Barry was the only bidder, and his £200 per machine bid was short of the commercial value of the machines. Davis, the auctioneer, refused to sell the machines to Barry, withdrawing them from sale. The Court of Appeal said that Davies was in breach of contract, and they emphasised that in an auction without reserve, it was not open to the auctioneer to reject the highest bid, which was the only bid in this case. This obviously could seem to lead to a harsh result, and therefore, if you are a seller, to avoid such situation when putting items into an auction, you would be well advised to place a reserve price on them. Otherwise, you could fall foul of this and end up selling at a ridiculously low price. So that's the position with auctions. They are an invitation to treat, and it is the bidder that makes the offer. It is then the auctioneer who accepts or rejects the offer, and as just pointed out, the approach is different depending on whether the item is with or without a reserve. Next, I will explore displaying goods for sale. So something that may appear at first sight to be an offer for sale may not be seen that way in law. For example, items in a shop window with a price clearly marked on them. case law on this point establishes that displaying goods in a shop is merely an invitation to treat. Two of possibly English law's most famous cases deal with this: Pharmaceutical Society of Great Britain and Boots, and the second case being Fisher and Bell. Fisher and Bell was a 1961 case. They both explain this point. In both cases, the court was of the view that the offer was made by the buyer offering to purchase the goods. So that's the point at which the offer was made, not the display of them for sale. It's interesting that in both these cases, the court was actually dealing with a criminal prosecution. So it's worth reading those judgments to understand how they came to the conclusion as to this being an invitation to treat. There's some American case law that we can draw contrasts with. Here they were dealing with contract, though, as opposed to criminal law, which was the case, which was the law being dealt with in Fisher and Bell. The American case is Lasky and Economy Grocery Stores. There, the court decided that the goods displayed constituted offers, and that the acceptance took place not on the placing of the goods in the basket, which was the case in English cases, but on the customer presenting them at the cash desk for payment. So in the next video, offer part 3, I'm going to talk about advertisements and whether or not they constitute an offer. That's generally not the case. Advertisements are an offer, but of course there are exceptions to this. If you found this lecture useful, then please could you subscribe to my channel and hit the like button. It really helps me out. And you can also have free notes downloaded from my website, uklawlectures.com. If you navigate to the notes menu there, you will find both the lecture notes and also recommendations by myself for books that will help you pass any LLB module on contract law. Thank you.